evidence of Dr. Sadasisi. The evidence of Dr. Sadasisi was not challenged or controverted by the accused person. Therefore, the Usman Koro Sisi, not being hurt or seen by his family for over 2 decades, can clearly and conclusively be presumed dead in terms of Section 1501 of the Evidence Act, when read together with the evidence of the prosecution witnesses. Furthermore, and most importantly, there are abundant case law authorities on the issue of copious directive in murder cases. The law knows that there are instances and circumstances where an accused person takes measures to destroy the body in order to avoid prosecution or conviction if prosecuted. Accordingly, there is evidence that a human being was killed by another human being. The latter can be convicted when the body of the former is not found. The important consideration is whether there is nexus between the accused and the killing of the victim, to the extent that the court comes to the conclusion that it is the accused who killed the deceased. In Babuka and the State 1996 NWLR PG 46279 at 296, Onu, as Justice of the Supreme Court, said, and I quote, as a matter of fact, conviction can properly be secured in the absence of corpus delicti, where there is strong direct evidence. It is true that the body of the deceased has not been recovered, but it is settled that where there is positive evidence that the deceased has died, failure to recover his body need not frustrate conviction. Quote. I should add here that an accused person has always been, I should add here that an accused person can also be convicted on strong and compelling circumstantial evidence in the absence of corpus delicti. The evidence need not necessarily be direct. I must say that there is enough evidence on record that the body of Usman Koro Sisi was burned to ashes. However, how can then the corpus delicti be found? The position of the law is that the effect that where there is facts before the court from which it can be inferred that the body examined by the doctor is that of the deceased and the medical evidence can be dispensed with. The Supreme Court of Nigeria in the case of Abbas Muhammad and the State 2017 LPELR 42098 Supreme Court had the following to say on the subject, and I quote, so the apparent choice of attack against the decision of the court below appeal against is on the identification of the cause. He was charged with culpable homicide, punishable with death. The position of the law is that where medical evidence is essential as to the cause of death, it is invariable also essential that the person who allegedly identified the cause of the disease to the doctor is called to testify as to the identification, unless identity of the disease can be inferred from the circumstances of the case. The position, however, is that if there are facts from which it can be inferred that the corpse examined by a doctor was that of the disease, the evidence of the person, dead or alive, said to have identified the corpse is not indispensable. Indeed, a conviction for murder can be made without the recovery of the dead body if there is positive evidence that the disease has been killed. Emphasis. In effect, the need for anyone to identify the body of the deceased to a doctor is not a sine qua non in all murder cases. Besides, it is also tried that medical evidence, through desirable in establishing cause of death in the case of murder, is also essential, provided that there are facts which sufficiently shows cause of death to the satisfaction of the court. Unquote. From the foregoing reasoning, I have reached the ultimate conclusion that the death of the disease occurred, and the prosecution has proved with the certainty required by law that the disease has died, and this I shall hold as a fact. With regards to the second issue as to whether the accused was the murderer, is a fundamental element of the charge of murder. The evidence led by the prosecution proves that the accused person is the murderer of the deceased. The testimony of Alaji Kanyi shows a grand scheme of conspiracy by Edward Singate, Peter Singate, and the accused person to kill Usman Koro Sisi. Alaji Kanyi gave evidence that they, BK Jata, Tukul Tamba, and Pa Aliu Gomez, were briefed by Edward Singate when they were going to get rid of someone, and they were taken to the residence of the accused person in Kerseri. Alaji Kanyi stated that at the time of arrival at the residence of the accused person, there were no guards or family members of the accused in his residence. Alaji Kanyi further gave evidence of how Edward Singate and Peter Singate went to the airport while he was instructed to be on guard at the residence of the accused person. Alaji Kanyi also gave evidence that he said Edward Singate and Peter Singate returned to the residence of the accused person from the airport. He stated that the accused person came with them to his residence. Alaji Kanyi further gave evidence that Edward Singate arrived at the residence of the accused person with the disease, and it was signaled to him, Alaji Kanyi, by Edward Singate that the disease was the one to be killed. Alaji Kanyi further went on to give eyewitness account of how Peter Singate used a pistol to hit the disease, followed by Edward Singate. He also gave evidence that the accused person also used the same pistol to hit the accused disease, whom at the time fell on the ground. He also gave evidence that B.K. Jatta, Tumpul Tamba, Pa Ali Gomez, and himself were instructed by the accused, by Edward Singate, to hit the disease with the same pistol, which they did. I have observed the demeanor of Alaji Kanyi whilst testifying in tears as to how Usman Koro Sisi was going to death. In my view, the tears from Alaji Kanyi were not crocodile tears. They were tears of remorse and regret. Alaji Kanyi testified that the place was full of blood and that Edward Singate instructed them to place the body of Usman Koro Sisi in his official car vehicle, which they did. Alaji Kanyi also gave evidence of how they, B.K. Jatta, Tumpul Tamba, Pa Ali Gomez, and himself were instructed to clean the blood in the house of the accused person, while Edward Singate, Peter Singate, and the accused himself left with the body of the deceased. I must say that the above piece of evidence by Alaji Kanyi shows that the accused person was a primary participant in the killing of Usman Koro Sisi. Alaji Kanyi, as an eyewitness, stated how the accused person, together with Edward Singate, Peter Singate, B.K. Jatta, Tumpul Tamba, Pa Ali Gomez, and himself used a pistol to hit Usman Koro Sisi to death. Alaji Kanyi's evidence also shows that when they finished hitting the disease to death with the same pistol, they placed his body in the disease official vehicle. I must say clearly that this evidence has not been materially controverted or challenged by the accused person, and there was enough cross-examination to destroy the veracity of the evidence of Alaji Kanyi. Under our criminal law, a person becomes a party to a crime if he or she actually does the act or takes or makes the omission which constitutes the crime, and this is provided under Section 23(1)(a) of the Criminal Code, Part 10, Laws of the Gambia 2009, which states, and I quote, when an offense is committed, each of the following parties is deemed to have taken part in committing the offense and to be guilty of this offense and may be charged with actually committing it. That is to say, A, every person who actually does the act or makes omission which constitutes the offense, unquote. On Exhibit P3A, the post-mortem report shows the cause of death as follows. I quote, a presumptive pathological diagnosis of death by fire is offered in the absence of a positive finding otherwise, unquote. It is therefore apparent on Exhibit P3A that the cause of death of the disease was by fire. The finding is clear that the conclusion of death by fire is based on a presumption which is offered in the absence of a positive finding otherwise. I must say that the said finding was based on the fact that the remains of the disease were what was presented for medical examination, and the report of which is contained in Exhibit P3 and 3A. This fact was born out of the evidence of Muhammad L.K. Boja, who testified as to how the remains of the disease were removed from his people found along Sukuta Jambur Highway and taken to the Royal Victoria Hospital for post-mortem examination. The nature in which the remains of the disease was presented for medical examination would have stated that the disease was hit with a pistol by the accused and his co-conspirators, taking into consideration of the following circumstances antecedent to the said death by fire, which is preferred to in explicitly in the post-mortem report. And I what? A, that the evidence led by the prosecution shows that there was a high scheme of conspiracy had by Edward Singleton, Peter Singleton, and the accused person to kill the deceased, Alaji Kanye. Alaji Kanye gave evidence of how they met at the house of Edward Singleton and were briefed by Mr. Singleton that they were going to get rid of the deceased. His evidence shows that they drove to the residence of the accused person, which at the time was empty, and there was no guards or family members of the accused person in the said house. B, the evidence of Ensa Mendy, Hamad Jangong, Lamin Dul, clearly shows how the accused ensures that the guards at his residence were not present at the residence, and so also his family members. Ahmad Jangong, who was the guard commander, also gave evidence that the accused person instructed him from telephone in his house to take the guards on patrol around BB Hotel because they got information that there is a boat coming with arms and ammunition. He also gave evidence that the accused person also informed him that he should pack his family members in his house and take them to the residence of Edward Singleton, as there was a party at the said residence. He also gave evidence of the accused person. That the accused person told him that he was sending a vehicle which he should use to take the family members to Edward's residence at Cape Point, Macau. Additionally, Lamin Tu and Ensa Mendy gave evidence that the accused person asked them to go to his residence. Both Ensa and Lamin Tu corroborated the fact that all the members of the accused person's family at his residence were taken to the residence of Edward Singleton on the basis that there was a party going on there. Ensa Mendy, Hamad Jangong, Lamin Tu also confirmed that they went on patrol to the beach as instructed by the accused person. They also confirmed that when they returned to the residence of the accused person from the patrol, they found cars parked outside the house. Ahmad Jangong stated that when he went inside the residence, Edward Singleton instructed him to return to the patrol with the guards, and they did, which they did. See, Alaji Kanye testified that after Usman Korosise was struck with a pistol until he fell down and died, they were instructed by Edward Singleton to place the body of Usman Korosise in his official vehicle, which they did. Alaji Kanye also gave evidence that when they placed the body of Usman Korosise in his official car, they went inside the accused person's house to clean the blood therein. He testified that when they finished cleaning the house, they went outside but found that Edward Singleton, Peter Singleton, and the accused person had left with the vehicles that were parked outside. The Edward Ensa Mendy, Ahmad Jangong, Lamin Dul, Fahabi Bubai, Alaji Kanye, Mohamed LK Boja, and Dr. Sana Sisi all testified that the car of the deceased was found along Sukuta Jammu Highway, burned to ashes. Their evidence shows that the body of the deceased was charred beyond recognition. It was ashes and bones of the deceased, which were recovered from the burnt vehicle and presented for medical examination. From the foregoing reasons, the above pieces of evidence and circumstances clearly shows that the accused was involved in beating the deceased with a pistol at his residence. It is also clear from the evidence that after the deceased was struck with a pistol on many occasions, his body was placed in his official car. Furthermore, the accused person, together with Edward Singleton and Peter Singleton, left with the body of the deceased after he was killed in the residence of the accused person. Additionally, the evidence of Habibul Bay shows that the vehicle of the deceased and that of Edward Singleton were seen heading towards Sukuta Jammu Highway at 1 a.m. of 24th of June 1994. From a careful study of the evidence on records, it is apparent that the above evidence did not only show that the accused actually took part in the crime of killing Usman Korosise by hitting him with a pistol. He has also taken part in the scheme to dispose of the body of the deceased by burning the body beyond recognition with a view to conceal the crime, and this I shall hold as a fact. All the prosecution witnesses confirmed that it was announced over the radio and newspapers that the accused, that the vehicle of the deceased was involved in an accident. However, the evidence of Pa Abibu Mbaye and Mohamed L.K. Boja as experienced police investigators shows that the said vehicle could not have been involved in an accident as it was announced. Their conclusion was based on the fact that the car had no dent or any remarkable thing which could suggest that the deceased was involved in an accident. The circumstances of this case clearly prove that the accused person with his co-conspirators found the body of the deceased in order to cover their heinous crime of killing their colleague state minister. But Habib Mbaye gave evidence that when he went to the mortuary in Banjul, where the remains of the deceased were taken, he saw Peter Singate at the said mortuary. He gave evidence that the hands of Peter Singate were in bandages, and he intentionally made a remark that there was a foul play in the death of the deceased. According to Pa Habib Mbaye, when he made the said comment, he noticed that the countenance of Peter Singate changed. It is an undisputed fact that the deceased was a cabinet colleague of the accused person and Edward Singate. The deceased was no ordinary citizen in the Gambia at the time, as he was the Minister of Finance. The accused person and his co-conspirators ensured that no investigation was carried out in relation to the death of the deceased for over 2 decades. The evidence of Pa Habib Mbaye and that when he began his investigation into the death of the deceased, he was summoned by the accused person to his office. He gave evidence of how the accused person looked at him and asked him to leave his office. Pa Habib Mbaye gave account of how he was dismissed from the police shortly after he visited the office of the accused person. On the cross-examination, the accused confirmed and maintained that to the best of his knowledge, no thorough investigation was carried out. The question that begs an answer is why was no investigation was launched into the death of the deceased by the accused person and his cabinet colleagues. If they did not have anything to hide from the public, why were the people who started investigating the case were dismissed from the service of the police? The obvious answer is that if the accused person had nothing to hide about the death of the deceased, investigations would have been allowed to go on without any form of intimidation towards the investigators or their dismissal, as in the case of Pa Habib Mbaye. It is the submission. I hold that the above piece of evidence corroborate the evidence of Alaji Kai and inextricably link the accused person to the death of the deceased. I therefore hold as a fact that the accused person took active part in not only beating the deceased to death, but that he also took part in burning his body beyond recognition in order to cover his crime. From the totality of the evidence placed before this court, I have reached the conclusion and satisfied that the prosecution has proved the second ingredient with the certainty required by law that the accused is the mother of Usman Koro Sisi. With regards to the third ingredient, as to whether the act or omission of the accused person was unlawful, is not in dispute. It is clear from the evidence led by the prosecution that the killing of the deceased by the accused person and his co-conspirators is unlawful. The accused person nor his co-conspirators had no legal basis for killing Usman Koro Sisi, and I therefore resolve the third ingredient that the act or the omission of the accused was unlawful. With regards to the fourth ingredient, as to whether the accused acted or omitted to act with malice aforethought and caused the death of the deceased, is an essential ingredient of the offense charge. Malice aforethought is defined under Section 190 of the Criminal Code as follows, and I quote, Criminal Procedure Code as follows: malice aforethought shall be deemed to be established by evidence proving any or more of the circumstances. A, an intention to cause the death or to do grievous harm to a person, whether the person actually killed or not. B, whether that the act or the omission causing death will probably cause the death or grievous harm to some person, whether the person is the person actually killed or not. Although the knowledge is accompanied by indifference, whether death or grievous bodily harm is caused or not, or by a wish that it may not be caused. C. Using violent measures in the commission of or attempt at a, a felony, unquote. The prosecution, in their bid to prove the fourth ingredient, led evidence that the accused person killed the disease with malice aforethought. Section 190 of the Criminal Code provides that malice aforethought is deemed to be established when a person has an intention to cause death of or to do grievous harm to a person, whether the person actually killed or not, or uses violent measures in the commission of or attempt at a felony. The cause of death and the intention with which the act or the omission causing the death can be inferred from the nature of the injuries and the weapon used by the accused. In the English case of Haim and DPP, 1974A 2ALER 41, the House of Lords held that an intention to cause death or grievous bodily harm is established if it is proved that the accused deliberately and intentionally did an act that it was probable that it would result in the death or grievous harm to the victim, even though he did not desire that result. Lord Hellsham stated on page 55 that, and I quote, if a man in full knowledge of the danger involved and without lawful excuse deliberately does that which exposes a victim to the risk of the probable grievous bodily harm, in the sense explained, or death and the victim dies, the perpetrator of the crime is guilty of murder and not manslaughter, to the same extent as if he had intended the consequences to follow, and irrespective of whether he wishes it or not. From the above authority, the circumstances of this case clearly shows the intention of the accused person was to cause the death of the deceased. Firstly, the accused person began to put his intention into action when he ensured that his residence is empty. He instructed his guards to go on patrol to the beach, and he instructed Lamindu, his official driver, to take his family members to the residence of Edward Singate on the pretext that there was a party at the said residence. Secondly, the evidence of Pa Abibul Bai shows that he receives information during investigation that the accused person blocked the vehicle of the deceased at the airport, such that the deceased could not leave until the accused person and Edward Singate arrived. He also gave evidence that the information he received further stated that even when the deceased arrived at the car park at the airport to leave, he waited for the accused person to arrive. That when the accused person arrived, he joined the vehicle of the deceased and they drove away. Thirdly, the accused person in conspiracy with Edward Singate and Peter Singate, BK Jata, Tumbul Tamba, Pa Ali Gomez, and Alaji Kanye used a pistol to hit the deceased until he died. The evidence of Alaji Kanye shows that even after the deceased fell down, they continued hitting him, and the whole place was full with blood. The accused person, by using a pistol to hit the deceased, knew very well that the use of a pistol can cause death or actual bodily harm. It is a fact that a pistol is a lethal weapon used by the accused person to hit the deceased with, and the inference that could be drawn from the use of the pistol to hit the deceased must be deemed to intend to cause grievous bodily harm, and that death would be a probable consequence of the said act. In the Gambia Court of Appeal decision of Abubakar Tunkara and the State Criminal Appeal number 68/2011, unreported, where it is held that, and I quote, there is no doubt that a person who delivers a violent blow with a weapon on a vulnerable part of the body must be deemed to have intended to cause such bodily injury, as he knew that death would be probable consequence of his act, unquote. Fourthly, the accused not only stopped at participating in hitting the deceased with a pistol, but took part in disposing the body of the deceased by burning same. Alaji Kani's evidence shows that the accused person, to together with Edward Singate and Peter Singate, left with the dead body of the deceased, which was placed in the official vehicle of the deceased. The accused person and his co-conspirator made the death of the deceased to look like an accident. In my view, it was simply to cover up such a horrendous crime by the accused person, Edward Singate and Peter Singate. I must say that these facts only constituted the intention of the accused person to ensure that the deceased was dead by all means necessary. The accused person, in his brief, contended that the prosecution failed to prove the evidence of the most crucial evidence, the alleged murder weapon. I must say that the absence of the murder weapon is not fatal to the prosecution's case in the absence of comparable evidence on the cause of death. In the Nigerian Supreme Court case of Muhammad Gaba and his Tech 2010 12 NWLRPG during the trial is, in my view, inconsequential. It is the intentional murderous assault on a vital part of the body which leads to conviction. There can be no doubt that a person delivering a violent blow with a stick or club on a vulnerable part of the body, such as the head, must be deemed to have intended to cause such bodily injury, as he knew that death would be the consequences of his act. Unquote. From the totality of the evidence adduced by the prosecution, there is sufficient evidence placed before the Supreme Court to hold the accused person killed the deceased with malice aforethought. From the evidence, the actions of the accused and the circumstances of the case shows that the accused had a discrete mental element of intention to cause the death of the deceased. I am therefore satisfied that the prosecution has proved the charge of murder beyond reasonable doubt against the accused person, and this as a whole as a fact. With regards to the fourth and final issue as to whether the accused person properly raised the defense of alibi in this case is worthy of consideration as a possible defense. If so, whether is he entitled to the defense of alibi is a crucial defense. The accused person denied being present at the scene of crime at the time that the deceased was killed. In his evidence in chief before this honorable court, the accused person testified that he drove to the airport in the vehicle of Chairman John. He further testified that from the airport, he joined Chairman John's vehicle to return to the State House with the chairman's driver. He testified that he reached the State House around 12 midnight and had a chat with the State Guard Commander, Captain Lan Tombon-Tamba. In my view, the accused person clearly put up a defense that he was not at the house around 8, it was 9, when the deceased was beaten to death by the accused person and his colleagues, including Alaji Kanye, contrary to the prosecution's case. The accused person has raised the defense of alibi in relation to the charge. That is, the accused person was somewhere else other than where the prosecution say he was at the time of the commission of the offense with which he is charged. In his book, Practical Approach to Criminal Litigation in Nigeria, revised 3rd edition, 2007, Justice Agaba, at page 62, held as follows, and I quote, where an accused person defends to a criminal allegation is alibi. What he is saying is that he was at another place when the offense was committed. In fact, it is a practical impossibility if a person or human being present at 2 different places at the same time that gives the defense its efficacy, provided it is established. Unquote. The London Auto continue at page 63 to 64 as follows, and I quote, the defense or plea of alibi must not only be raised, but must be promptly and properly raised by the suspect to warrant any consideration. To start with, it must be mentioned at the outset that the relevant time material to the defense of alibi is the exact time the offense was committed. Thus, it's not sufficient that the suspect was somewhere else at a time antecedent or subsequent to the commission of the alleged offense. Rather, he was somewhere else and could not have been present at the scene of the crime. As common as the defense of alibi seems or sound, it is not raised merely by saying, I was somewhere else. It must be properly raised. The defense of alibi is said to be properly and duly raised only when the defendant not only stated that he was not at the scene of crime, but somewhere else, but also goes further to satisfy the evidential burden on him, giving particulars of the other place which he claims to be at the time of the offense was committed. This he must do by naming the exact place he was, the person he was with, or who could testify that he was there at the time. Where an accused person fails to give particulars of the place he was at the time of the commission of the offense charge, the names of those who were with him, if any, and the time they were together, agreeing with the time the offense was committed, he is said not to have properly raised alibi, where he gives conflicting stories as to his whereabouts at the material time under the consideration. He has not properly raised alibi, and there is no obligation on the prosecution to go on investigation. There must, as the burden to disapprove alibi on the prosecution, the defendant on his own part must also discharge what is called the evidential or secondary burden of court. On the time to raise the defense of alibi, London Auto at page 67 said at the time, the right time to raise the plea of alibi is as soon as the suspect is apprehended by the police or other law enforcement agents. In fact, it must form part of his statement to the police if he were to make any statement. The reason is that as soon as his plea is raised and reasonable particulars are given, the police or other law enforcement agent is on the duty to do investigation, to investigate the alibi, to ascertain its truth or falsity. The prosecution refers this court to the case of the prosecution refers this honorable court to the decision in the case of the state and Abdullah Baji and three others crime case number X012/AO. Judgment delivered on the 16th day of December 2020 by Honorable Justice Senabu Wada Sisi, unreported, wherein Honorable Justice Senabu Wada Sisi held as follows, and I quote, it is right that in raising the defense of alibi, the accused must furnish the police with full particular details of the alibi at the earliest opportunity to enable the police to check the details. I must quickly emphasize that the burden to prove the guilt of the accused person lies throughout on the prosecution. The requirement of the accused to provide details of the alibi does not shift the burden of proof to the accused, but it weakens the defense of alibi. See the case of Sowami and the state. In the instant case, the defense of alibi was raised during trial. This means that the defense was not raised timeously and was therefore not investigated. It is instructive to note that the first and the third accused persons maintained silence in their cautionary statements about their whereabouts at the time of the attack. The accused persons did not call anyone to call none of their friends that they said they were with, and failed to lead further evidence in support of the defense. In Orago and the State, 1992 NWLR, the court held as follows. It is not proper way of raising a defense of alibi, or for an accused to merely show that he was somewhere at the time antecedent to the time of the crime was committed. The time of the crime was proved to have been committed. He must go further to show that because he was at the place at that time, it was impossible for him to have been at the scene of the crime when it was shown to have been committed. In support of this principle enunciated in Orago and the state, the court had earlier in Obioda and the state held that the law is that it is not enough for an accused to raise the defense of alibi at large. He must give adequate particulars of his whereabouts at the time of the commission of the offense to assist the police to make a meaningful investigation of the alibi. If the accused person said he was in a particular locality or with a particular person or persons, he gives a lead as to the specific place, the name and or addresses of the contact and the relevant people. He was away from the scene of the crime, unquote. In our instant case, the accused raised the plea of alibi in court, precisely during his examination in chief. I must emphasize that the accused person did not raise the plea of alibi with the police when he was confronted by the police in relation to the allegation contained in the information, in this case. The accused person refused to speak to the police and simply invoked constitutional immunity. That never works. I have looked at Exhibit A, the cautionary statement of the accused person, and made no mention of his whereabouts on the night in question or thereabout when the offense was committed. Under the rule of alibi, any accused person setting up alibi as a defense is also duty-bound to give the police at the earliest opportunity some tangible and useful information relating to the place he was and the person with whom he also was. In our instant case, the accused person, by failing to inform the police at the earliest opportunity when he was arrested, deprived the police of the opportunity to further investigate the alibi to ascertain its true falsity. Thus, failure of the accused person to raise the plea of alibi timeously and properly warrant the same to be rejected. The prosecution refers this honorable court to the Supreme Court case of Samson Ebehimi and another versus the state. Supreme Court 220/2008, judgment delivered on the 6th day of March 2009 and reported 2009. All ALLFWLR PT 486-182. And in that case, there was a robbery between 11 p.m. on a particular day and 2 a.m. the next day, in which PW3 4-5 lost various items, including house and car keys. At 5 a.m. of the same day, the first appellant was arrested by a group of youths, and in possession was a hammer and keys. The said keys were later identified to belong to the PW3, 4, and 5. That the appellant raised the plea of alibi for the first time at his trial, and same was rejected by the trial court. It upholding the lower court's decision that the defense of alibi was rightly rejected by the trial court. The Supreme Court of Nigeria held that for the defense of alibi to be properly raised, it must be raised at the earliest opportunity when an accused, so that the police will be in a position to check the alibi. The Supreme Court concluded that where the alibi is raised for the first time at the trial court, it does not warrant consideration by the court. In our instant case, the accused, by raising the defense of alibi for the first time on trial, it is not worthy of consideration by this honorable court, because the accused person has failed to raise the defense of alibi at the earliest opportunity when he was confronted by the police about the allegation contained in the bill of indictment. And this I shall hold as a fact. In view of the fact that the accused person raised the alibi for the first time during the trial, when he opened his defense, and after the prosecution has closed his case, the evidential burden was placed on the accused to prove his alibi on the preponderance of probability. In the case of Abu Bakr Ibrahim and the state, it was held, and I quote, it is possible in some cases for the accused to refuse giving voluntary statement to the police before trial, in which case he will not then raise the alibi. But if at the time an accused person who never raised an alibi when making his statement to the police or on oath in his defense raised the issue of his not being at locus criminis at the time the offense he is alleged to have committed took place, raised a new issue entirely from the alibi. For alibi to be a defense raised before trial for the police to investigate so as to decide its veracity. But once before the court on trial, the accused person who raised a defense of his being elsewhere at the time of the offense was being committed has made an assertion he must prove. I have, unquote, I have also observed that from Exhibit B, the voluntary statement, and that the accused refused to give a voluntary statement to the police on the basis of immunity. When he was arraigned, he did not offer any defense of alibi until he opened his defense. The accused person testified that from the airport, he drove in the car of the chairman to return to the State House. He also stated that he was alone with the driver of the dead chairman, one Pamala. The accused also testified that when he reached the State House between 11 p.m. to 12 a.m., he chatted a little with Lantombong Tamba. On the cross-examination, he acknowledged that both Pamalang and Lantombong Tamba are both alive and present in the gang. The prosecution posed the question if the accused intend to call the aforementioned as witnesses to which he responded in the negative. The accused person did not call the said Pamalang or Lantombong Tamba to testify and support his assertion that at the time of the commission of the offense under consideration, he was at the State House, and the inference that can be drawn is that the defense of alibi is simply an afterthought, and this is a rule as a fact. The accused person failed to challenge the evidence of alleged crime that he in fact struck the disease with a stick, which resulted in the death of the disease. Therefore, the purported defense of alibi put forward by the accused person should be viewed with the context in the strong evidence put forward by the prosecution. In the case of Chema G and the state, Supreme Court Nigeria held that, and I quote, there is nothing extraordinary or exotic in a plea of alibi. Such a plea postulates that the accused person could not have been at the scene of crime and only inferentially that he was not there, even if it is not the duty of the prosecution to check on a statement of alibi by an accused person and disapprove the alibi or attempt to do so. There is inflexible and or invariable way of doing this. If the prosecution adduces sufficient and acceptable evidence to fix the accused person at the scene of the crime at the material time, solely his alibi is thereby logically and physically demolished. Unquote. From the foregoing, I reach the conclusion that the accused has failed to establish the defense of alibi as required by law. I therefore hold as a fact that the accused person is not entitled to the defense of alibi put forward in this case and is hereby rejected and as it lacks merit and not tenable. I must state that I believe the testimonies of Alaji Kani and Sabendi, Hamad Tangam, Lamin Dur, Fahabib Pai, and Muhammad L.K. Bojang depicted the true picture of how Usman Kolo Sisi was murdered in cold blood. And I must emphasize that the law does not concern itself with trifle, as stated in the progeny of the Latin maxim, de minimis non curat lex. I have no cogent reason to disbelieve the testimonies of the prosecution witnesses because defense witnesses themselves admitted that there was no reason for the prosecution witnesses to lie against the accused person. I have had the opportunity to watch the accused person, our Mami Minty, closely when they were giving evidence. I must say that their demeanors were not convincing at all, and I am not persuaded by it. As Mami Minty and our Minty admitted on the cross-examination that they would do anything possible to make the accused person happy and protect him. In my view, these admissions on cross-examination leave much to be desired. I am therefore satisfied that the prosecution has sufficiently established the constituent elements of the offense as charged. I am further satisfied that the prosecution has proved their case beyond reasonable doubt, and the accused person, Yankuba Touray, is accordingly found guilty and convicted as charged. You are reminded of the right to appeal against this conviction. Prosecution? Any previous conviction known? Defense counsel, do you have any plea in mitigation? Yes, that is the prosecution. What is it? A few words? Yes, if you want to, okay, if you want to say anything? You want to say a few words? Then counsel, yes, let me hear what you are saying. That is not, you want to say a few words? Yes, if you want to, okay, if you want to say anything? Yes. 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 Okay. Yes. I am not getting you clearly. Hmm? Yes. I am not getting you clear. All right. Sorry. But yes. So under the circumstances, considering the time, I think I will have to adjourn this matter for sentence. Yes. Yes, yes. When we send it. Yes. 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 I think the matter is still pending before the Supreme Court. The matter is concluded. So he's pending there. Yeah, but it's a matter before the Supreme Court. Yes. So prosecution. So what I'm saying, do I proceed with the sentence or we take an adjournment for the sentence? Yes, I was suggesting to take an adjournment for the sentence. Okay, so let me prepare the sentence then.
Recording in progress.
Sentence. Have been found the convict guilty of murder, the murder of Usman Koro Sise in cold blood, and having considered that this court does not have any discretion under Section 188 of the Criminal Code, the convict Yankuba Touray is hereby sentenced to death. And pursuant to Section 252 of the Criminal Procedure Code, the said sentence of death shall be by hanging. So this court will rise.